Yes, yes, please. Please, Sandesh.
Yeah. No, who is the host? Can you ask host to?
India.
Yeah. Bindya, please allow both of us. I'm also trying from one more device.
I admit you. I am also there only.
Okay. Got it.
In progress.
Ma'am, she's trying to connect. Have you got any request? Ivana is trying to connect. Okay.
As of now, I could not got any request from her. Sandesh. No, your voice is also.
Ma'am, she's trying to connect.
Yeah. No. This is a Vindhya also. Where is the Ivana, Sandesh?
She's trying to connect.
Okay.
Hello. A very good evening to all the viewers and juries present over here for the webinar on the topic of data privacy as a fundamental right. One moment, ma'am, please mute yourself. A very significant and relevant topic in the modern world. So I take this extremely privileged opportunity with great pleasure and excitement that to extend a warm and heartfelt welcome to a distinguished scholar, educator, and trailblazer in the field of law and academia, Dr. Alka Patil ma'am, Assistant Professor, Mumbai University, who is also a coordinator for today's highly significant program. Dr. Alka Patil's journey is a testament to her unwavering commitment to knowledge and excellence. With academic qualifications that include an MCOM, LLM, UGC NET, PhD in law, and even a diploma in cyber law, she exemplifies the pursuit of multidisciplinary knowledge. Her journey in education began in 2012 when she served as an assistant professor of law at Swami Vivekananda Law College in Chembur. Since then, her path has been marked by dedication and a passion for teaching. In September 2012, she joined the esteemed University of Mumbai as an assistant professor of law, where she has been instrumental in shaping the minds of future legal professionals. Dr. Patil's repertoire of subjects at the departments of law, University of Mumbai is both diverse and impressive. She imparts knowledge in areas such as law and social transformation, Indian constitutional law, judicial process, legal education, research methodology, comparative constitutional law, administrative process, and much more. Her dedication to nurturing well-rounded legal minds is truly commendable. Notably, Dr. Alka Patil ma'am completed her PhD in law with a focus on the constitutional philosophy of good governance and the role of Supreme Court in India. Her commitment to research also extends to her minor research project, which explored the right to health, the role of Supreme Court in India, and was funded by the University of Mumbai. Let us not forget that Dr. Patil's ma'am's contributions have garnered international recognition as she received an appreciation letter from none other than Prime Minister Justin Trudeau of Canada. Furthermore, she has been an invitee as a guest speaker on the topic of framing of the Indian Constitution at UPSC, a testimony to her expertise in the field of law. Last but not the least, Dr. Alka Patil ma'ams engaged in a questions and answer session on DD National Sahabri Doordarshan channel during the Constitutional Day of 2022, demonstrating her commitment to knowledge dissemination beyond the confines of the classroom. In conclusion, Dr. Alka Patil ma'am is not only an educator but also a true academic luminary whose contributions have had a profound impact on the field of law and education. Her dedication, knowledge, and tireless pursuit of excellence serve as an inspiration to all of us. Please join me in extending our warmest welcome to Dr. Alka Patil ma'am, and we eagerly anticipate the insights and wisdom she will share with us today. Thank you, ma'am, and welcome.
Alka ma'am, I think you're on mute.
Thank you so much, Bindya, such a wonderful guest. Ladies and gentlemen, my name is Dr. Mumbai. To distinguished guest, Ivana Batuli. The topic for the conference is data privacy as fundamental right. So in India, for a very long time, data protection law or privacy was never an issue. But in technology and the growth of data protection and privacy, it's become a matter of the concern. In 2017, the Supreme Court recognized the right to privacy as a fundamental right. After this, government was bound to respect that individual privacy and the legacy. In 2018, Reserve Bank of India released that on the online portal, we used to save our card detail. Under this notification, Reserve Bank of India mandates. So instead of wasting all this important topic for my end, I hand over this to Mr. Sandesh Jadhav. So please, Sandesh Jadhav, introduce our today distinguished guest, Ivana Madam, and go ahead.
Good afternoon, everyone, and thanks a lot, Ivana, for joining our invitation from Department of Law, University of Mumbai. We welcome you for this particular topic. So to give brief about Ivana, Ivana is a privacy and data protection professional. She is acting as a Chief Privacy Officer at Wipro. She is also a visiting faculty at Cyber Security and Privacy Executive Fellow at Pamplin Business School, Virginia Tech. She helped global organizations with the privacy by design programs and the privacy and ethical challenges relating to artificial intelligence and big data. Ivana has been awarded as a Woman of the Year in 2019 by the Cyber Security Award. She's also appeared in the Forbes list. Ivana is also co-founder of the Women Leading in Artificial Intelligence Network. She has co-founded the Women Leading in AI Network, a lobby group of the women from different backgrounds, which is aimed at the mobilize the tech industry as well as the politics to set clear governance around the AI so that it would work for everyone and is constrained by the human values. She is also a public speaker and a commentator. She regularly speaks at the event worldwide and comments in the media and headline stories where the tech economy intersects with the privacy and data law and politics. She's a co-editor of Willis Artificial Intelligence book on artificial intelligence in financial services. Her new book, An Artificial Revolution, is already published and it's available for your reading at Amazon Books. So she's also a regular contributor to the Yuan, and she's working continuously on all issues around the privacy and ethics in artificial intelligence. So I congratulate Ivana for all her success. And again, thanks a lot for accepting our invitation. And thanks to accept to act as a speaker for the University of Mumbai Department of Law. Over to you, Ivana.
Thank you so much, and it's my pleasure to be here. And I wanted to start this by talking about how I got into this world myself of privacy, which was when I was about 16, which is, as you look at me and see, I'm quite a while ago. And at the time, we were in a different world. I am 44 now, no mystery. And I was 16 when I first had an interest in privacy. So the way I wanted to talk to you in this time is I wanted to first take you into how I got into this, and then about what is privacy today, why privacy has become so crucial, what it means in the digital age we live in now. And I wanted to talk to you about this global element around privacy. And then I will move on to India, what this new privacy bill means in the global scale. And then finally, I would like to walk you through what is the responsibility that privacy leaders and lawyers have within organizations in relation to privacy. So I will just start quickly by telling you that when I was 16, I was living abroad. At the time, I'm originally from Italy. And at the time, I was slightly concerned when I was in America about the beginning of the use of cameras. But what struck me at the time, and what continues to strike me, whether it's in any part of the world, is that privacy is very much a value that binds the world together. In the sense that although privacy is very different and is conceived in many different ways, in India, in Brazil, in America, and Europe, in reality, there is a common thread around the world, around privacy. And the common thread is really about autonomy and human dignity. And it's very important that we pause for a moment and we think about these two worlds, autonomy and human dignity. All the rest will follow. The reason why I'm saying this is because privacy will have different nuances around the world. It's going to be very different depending where we are in the world. Privacy in India is different from privacy in China, is different from privacy in other parts of the world. But what is nevertheless interesting is that there are some similarities, and there is an understanding that it is that there is something about human dignity that is at the heart of it. See, my own personal journey has always been on privacy, not just and not necessarily as an individual right. Sometimes people ask me, you must be so worried when you work, on the internet, and you must be pressing yes or no to every single button. But in reality, I am not particularly focused on that. My approach to privacy has always been around the value of human dignity. In fact, I do come from a human rights background when it comes to this world. Now, if we stick to what we said, autonomy and human dignity, then it's obvious that what's happened over recent time around artificial intelligence, generative AI, blockchain technology, and digital identities, and all the things that you know really well. All these things, they have really pushed the concept of privacy further. Over the last few years, what we have seen all over the world, discussions really around these concepts of autonomy and human dignity. So, for example, when we now navigate the web, when we decide to buy something online, what happens is that our data is often used to track us. That means that a lot of information is gathered about us as individuals. And a lot of information are then used, especially through the use of big data, to create profiles about us, which means to understand what we like, make predictions, what we don't like, and do what is called micro-targeting, which a lot of it is good, which is really responding to what we are as individuals, and therefore sending and tailoring adverts to our personality. And this is all easy to understand because we leave so many traces around us when we navigate the web. In the past, going from one room to another was a matter of navigating scent, perfume, leaving traces of things about us. And you have to transport this into the digital ecosystem. How much we transport of ourselves from one environment to the other. And all this data gathered together, they create a profile about who we are as individuals. So when it comes to autonomy, this is very relevant in the digital age. Because for as much as individual recommendations for filing great, at the same time, they leave us less space for autonomy, less space for decision-making. The same happens with predictions. The use of artificial intelligence and big data for predictive analytics offers fantastic opportunities, but at the same time, it can turn into self-fulfilling prophecies. The reason why I'm saying all this is because now more than ever, the concepts of autonomy and the concepts of human dignity, they are at the heart of the way that we are conceiving globally privacy. And there is indeed, amongst all the differences between countries, and it's really important to focus and to start by focusing on what binds us together, which is always far more than what sometimes brings us apart around the world. And I think there is a recognition of the massive and enormous potential that we have, but also the risks that come with it. And one, in this sense, to pause for a moment and think about generative AI. If you think about tools like ChatGPT, which have made an enormous splash over the last few months, they have brought the amazing possibility to have human knowledge at our disposal, to make our life better. As lawyers, we and you will be using these tools a lot. To summarize, to co-create, to empower yourself. And I always think that it's not people whose job will be a risk. The jobs which will be a risk are the ones where people are not quick enough to familiarize with AI, whatever the job is. So generative AI has come to the world, bringing enormous headwaves, making enormous headwaves all around the world, being accessible to 100 million people who are using it on a daily basis. Tools like ChatGPT, but ChatGPT is one of them. The problem with these tools is that alongside fantastic opportunities, they bring challenges as well around data scraping. And 7 data protection authorities around the world issued a statement just a couple of weeks ago around potential of a data breach that could emerge, massive data breach, which could emerge from data scraping, which is probably the hottest and most contested area in privacy law at the moment. Think about, for example, legislation like the Californian CCPA, which allows class actions. So think about, imagine this in the view and looking at this through the lenses of data scraping. So that is one issue. The other issue is obviously around accuracy of information, which is around the world, as it is in India, privacy data protection bill, key principle around data protection, and also around other legal issues that come up to the fore, which you lawyers will be at the very heart of, around copyright, intellectual property, around, as we said, security, the possibility of infiltration, security, cybersecurity leaks that may emerge from the use of these tools. For example, the use of these tools coding may be particularly risky from a cybersecurity standpoint. So just to summarize and sort of my first remarks, I wanted to say that now more than ever, autonomy and human dignity are pillars that, despite all the differences that we have at global level, bind a lot of us together in trying to understand how we navigate the complexity around new technologies emerging and the safeguarding of the rights of people and individuals. Now, privacy and data protection are two very distinct fields. Privacy stems, talking here as a European, from a human rights background, from a human rights standpoint. In Europe is enshrined in the fundamental rights of individuals, in the European Charter, and is very much around, it emerges from a human rights background. Data protection, arguably part of one of the tools that we can use to ensure that privacy is safeguarded, is around the measures that we place around data to safeguard this information. The GDPR in Europe is a data protection regulation, as much as India was talking about data protection. And it's very important to really note this. I wanted to say that we live in a very interesting time on privacy. And arguably privacy lawyers, there hasn't been better time to be in privacy than now. And the reason why this is happening is because whether you work in tax, whether you work in copyright law, whether you work in contract law, you will find that privacy is a thread that binds a lot of things together. If you are in contract negotiation, contract law, you will be liaising, discussing things about, liability, and when it comes especially to the use of generative AI and these technologies. In any sector you work in, there will be an increasing importance of privacy, which is less and less as a standalone discipline, and more a thread that brings together many aspects of our life and our legal system. We have privacy laws in many, many countries, and I am delighted, fantastic, to see what is happening in India. And the reason why I'm very happy is because whatever happens in India will have a massive influence moving forward. There are elements of the India Data Protection Bill which are absolutely fascinating, and they have a unique way of dealing with privacy challenges, from the concept of the data fiduciary to the responsibility given to the individual, to the legal basis and interesting concept about the legitimate interest on, which is very different, legitimate interest in legal. We have legislation everywhere in the world. I was in Brazil a couple of weeks ago talking about privacy and as a human right, as a fundamental right, and talking about how we navigate privacy in the age of AI. And very importantly, what happened in the, and what was really interesting to realize, as ever, is wherever I go around the world, what binds us together is the knowledge that, especially now with this new technology, and particularly with artificial intelligence and the use of big data analytics, our role as privacy professionals, as privacy leaders, as lawyers, becomes more and more important to ensure that the benefits of these technologies are shared by everyone. So this is the first message that I wanted to share with you, which is about the role and the importance of the privacy profession that will emerge, and is emerging more and more, not as a standalone profession, but as something that really binds different elements, that really brings together different elements of the law, of technology altogether. Arguably, the way the privacy is evolving now, the skills and the talent that we will need around it will evolve and will change. I want to say now to lawyers that it will be very difficult to do privacy without knowing technology. I want to say to lawyers now, and especially a younger generation of lawyers, that it's really important as we navigate new technologies to understand how we code privacy into everything that we do, in every product that we create. How we bring privacy by design from a purely philosophical concept into product design. I am very hopeful in a new generation of lawyers, new generation of privacy professionals, able to bring together the law and the tech and bridge the common gap between the two. In this sense, I grew up with GDPR, and I cannot tell you enough how complicated the GDPR was compared to your law, which is simple with use cases, real case scenarios, explanations. What I'm trying to say here is that the future of privacy will depend on a generation of lawyers and privacy practitioners able to bridge the gap between the law and technology, able to think straight about the concepts of fairness, concepts of accuracy, the concept of transparency, consent. How do we code them into the product? How do we ensure that actually all what we're doing is to technically embed privacy by design? So, for example, when it comes to collecting location data, we don't need to really collect the actual location of an individual. We can collect the information regarding to the nearest point next to them, so that we can use federated learning and differential privacy, so we can add noise to the data. And even more importantly, that we are able to use synthetic data, which is data that mirrors the characteristics of the data, the natural data, but it's not, which means that it does not impact on individuals. So that is my second message to you today, which is that, and I gave the same message when I was in Brazil 2 weeks ago, speaking to lawyers, that we really need to make the most to bridge that gap between the law and technology. What cannot happen in the world of privacy moving forward is that cybersecurity specialists, programmers, coders, and lawyers, privacy lawyers, speak different languages. That is going to be problematic. It's imperative on us, coming from a legal background, that we familiarize with what an algorithm is, how we can prepare the right data sheets, what it means to actually massaging a set of data so that can be put and fed into an algorithm. What encryption looks like, not just as encryption, but what does it mean in practice? What kind of encryption are we going to put in place? How are we going to ensure that a lot of stuff happens in the device rather than in a centralized place? And what is the role of the centralization within all this? These are key challenges for the legal profession moving forward, is to embrace not just the law, but the technology, understanding its fundamentals, bridging the gap between privacy and tech. The other thing that I wanted to talk to you about is that what is the role of us lawyers within organizations, privacy professionals, but not just privacy professionals like me, lawyers like you, but also people who work in another way of the law, but they do come across privacy. So a big challenge that we have moving forward is how we establish privacy at the heart of the organizations where we work for. And this is not going to be an easy challenge. Privacy is a transformative journey, bringing together lawyers, program managers, HR, cybersecurity, risk management. Organizations will have to bring together all these different aspects of the law, of the different aspects to create a privacy program. The role that what will happen now is for organizations, that is really important to do, is for organizations to create task force that are able to understand the impact of the legislation, to embrace the legislation, to understand its impact, to understand how some technological solutions advise to empower individuals, and so on and so forth. When the GDPR came up in Europe, and by the way, the GDPR is by no means gold standard in privacy, and I'll come to that from sort of a global perspective. But it's really important to understand that when GDPR came out, it went live in 2018. When it came out, interestingly, there was a lot of criticism around this legislation. Businesses were saying can't comply. There was a lot of paperwork, a lot of bureaucracy that has to go with it. And inevitably, one consideration that I wanted to make around GDPR, there has been no doubt that GDPR has furthered power of the companies that are already quite big. Because companies like the Google, the Amazon, all these big tech, they've had the resources, the power to embed and construct and build innovative solutions, such as dashboards and consent management platforms, really empowering individuals. Similarly, they've also been able to set some of the standards around privacy themselves. Think about the wider digital advertising system, all the issues and all the debates that we've had in the past over tracking. The reason why I'm saying this to you is because looking back and looking from a European standpoint to this, the day after the Digital Services Act came into place, looking back, I am thinking that one of the things that the criticism that we've had, and they have regarding GDPR, has been around how it has empowered the large tech companies even further, which is not a problem in itself. But the reason why I'm saying this is because it is those companies that have had the possibility to create, build all compliance tools that were needed. For smaller companies, and arguably companies that were trying to innovate, it has been more difficult to put in place what was prescribed by GDPR. For me, this has been a learning curve, which many of you will probably know about. I wanted to let you have this because we often think about how the cost of the compliance exercise, how it's been, so what has happened over the last few years, and how organizations with a lot more funding than others have been able to establish the guardrails, the tools, the empowering tools for individuals, for example, to exercise their rights and in a much better way. This is also leads me to something else, which is important to you lawyers, which is the inextricable link between competition law and privacy law, which will become further and stronger moving forward, and something that I really want everybody to think about. It is very difficult, although privacy law and competition law, they are different fields, and they should be seen as different. One thing is privacy, which is based on fundamental rights. One thing is competition, which talks about the fair behavioral practices of businesses within the economic sphere. Nevertheless, there is more and more an intersection between these two. And more, for example, in European jurisprudence, you see that data privacy is as a key part of discussions between mergers and acquisitions. So that's another element that we really need to bear in mind, the link between these two areas. So this years of GDPR, this is what we've learned. So we've learned there's some things that work, some things haven't. We have learned in Europe that it's taken a very, very long time to get some enforcement running. It's the big companies have had it easier to comply, and maybe the smaller companies have had it more complicated, and arguably the ones that were going to bring more innovation and maybe a healthier economic landscape to Europe, where we pay consequences now. And we have learned of the link between Now, what happens with new technologies? One thing that you will be told, I am told, everybody's told, is that we have to speed up, we have to innovate, and we have to do it quickly because there is a race globally, and this is where, because technology is what is needed to improve our countries and our societies, which is true. You will have seen how data has become a key issue, not just from a technological standpoint, but from a geopolitical one. The debate around data sharing and around data localization has been arguably a debate around geopolitics rather than that finds in data and in AI a fantastic ground. I don't have to tell you, who know this much better than me, that data is part of this wider, it's part of a much wider discussion. And then you might have heard of a case called Schrems 2. Schrems was a Austria is a country in Europe, an Austrian lawyer called Max Schrems, and he was based in Austria, and he was using Facebook, and he didn't want his data to be sent to the US. The reason why he didn't want his data to be sent to the US is because he was concerned about the different treatment that American citizens and European non-American citizens have in Europe when it comes to access of data from law enforcement agencies. The European Union has this concept of essential equivalence, which means that when data is going out of the EU, the data holders, the data principals, they have to receive the same or equivalent treatment that they would receive in Europe. I cannot stress enough how troubling, stressful the experience of dealing with this court case has been over recent times. Luckily, America and in Europe, they agreed on a new framework to share data between the two countries, which may be challenged again. But the reason why I'm bringing this to your attention is because the issue of data sharing is very much of a privacy issue, which will end up on the table of any privacy lawyer, desk of any privacy lawyer. But it's also a hot, contested political issue. India's approach is drastically different from Europe in a way which I appreciate. Whilst Europe says data cannot be transferred anywhere, except when there is a mechanism in place. The India approach is different. It says data can be transferred anywhere except. So it's a liberal approach, which is welcome compared to the previous draft of the bill. Of course, data localization requirements, for example, around financial data, they remain, as in other countries, parts of the world. But I think this liberal approach to data sharing is very important. And this is the third point I wanted to make. I don't remember if it was number 3, but I think it was number 3 or 4 that I wanted to make. To privacy lawyers and non-privacy lawyers, but lawyers who will be involved in data sharing or will be involved in the crafting of governance around the bill in organizations, governments, whatever it is the importance of data sharing, the understanding that we all need to have, all of us in privacy need to have around the strategic importance of data sharing. Data, some people call it the new oil, some people call it new capital. I like the word sand because we need a lot of it. Only one little thing is not going to do much, but you need a lot of it to make sense and to some value. But it's really important that we focus on that, on understanding the issue around data sharing. And again, this is where technological solutions support, because they can minimize the risks. The recent news about BRICS and the entrance of new countries and the strengthening of that will also have an impact. The reason why I'm saying this to you is because BRICS brings together countries which have got very different approaches to privacy, ranging from Brazil to China to India to Saudi Arabia, very different approaches. Nevertheless, you will see and we will see more and more, and this is why our job is so interesting. That data sharing, data collection, data localization is not just a legal matter, but it's very much also a political. Data localization is also related to harnessing the value of data within borders. Everywhere around the world in recent years, everywhere, we have seen an increase of data localization with the idea that we can harness, collect the data, and we can use it for our benefit within nations. So we have seen a lot of data protection increasing data protection, but we also have seen a lot of data protectionism increasing. At the same time, these two things have happened at the same time, which is really interesting from a geopolitical standpoint, to see these two elements coming at the same time. And at the same time, the power of multinational companies getting bigger and bigger in a way which is definitely beyond borders and beyond nations. This has a major impact on force activity. Now, I want to close for the next few minutes on AI. And I want to, you may say, well, how does privacy and AI, what's the impact? How do they get together? What do I have to do as a privacy lawyer on it? Well, quite a lot, actually. Although AI is not just about privacy, obviously, because there are a lot of AI that does not need any personal data, although it may have an impact. And there is a lot of talk about responsible AI, what it means to responsible AI. I wanted briefly, if you're interested in responsible AI, I've written a lot about it and just recently a report for Council of Europe, but I wanted to really talk about the intersection between privacy and AI. Now, and in there, I go back to the concept that I mentioned at the very beginning around autonomy and dignity. Okay. Over the last few years, we have seen an increase of automated decision systems, which is basically software making decisions about individuals. We have seen this for a long time. Whether you can have a mortgage or not, promotion of work or not, hired or not, systems that look at your movements into a new stage, a lot of stuff like this. Now, there is obviously a privacy implication. For example, and you just need to think of the key principles underpinning privacy. One, for example, is the concept of accuracy. And there are also some conflicts within privacy law. For example, there are concepts around contradictions and conflicts between accuracy, data minimization, and fairness. You need a lot more data, for example, to ensure that an AI module may be fairer in its output. To do so, that is obviously a conflict with data minimization. If you use data which is accurate, then you may have an impact on fairness. the output. So fairness in the processing and in the output is privacy principles. And sometimes you may need to manipulate or massage in the data to have the equity that you need in the end. We can talk about all this separately. It's a massive area. But what I wanted him to say, or for example, issues like transparency. The Italian regulator came up with something says consent cannot be valid if the algorithm is not transparent because the individual doesn't know what they're consenting to. But what does it mean for an algorithm to be transparent? And are we sure that a more transparent algorithm is a more precise and inaccurate one? How do we ensure that we have the right data sets? How do we make sure that we have all the legal basics for using this data, for training our systems? How do we make sure that when we our companies, when you work for an organization, the company's invested in AI or buying AI products, how do we perform their due diligence from a privacy standpoint? Transparency, human oversight, meaningful transparency, human oversight, security and robustness of these systems. Data subject rights. What do data subject rights, right of access? You will deal, and it's not in the privacy bill, but it will be in the Digital Act in India. It will be in the Digital Act, will be data portability. How does that apply to AI? Those are all things where we need to put our heads together, and I haven't got answers. I'm trying in the sense that I'm trying, for example, to work on issues like fairness and tools for fairness in AI. Rewriting a definition of accuracy, which is more based on output rather than based on the actual data. So we're trying. And it's a debate where I would welcome anybody, especially from every single part of the world. We need to discuss this. When I was speaking about these things with your colleagues in Brazil, it was fascinating because they're facing the same challenges. We are looking at things like how do we make sure that an algorithm is fair? What is the role of lawyers within it? This is all a discussion that we need to have. So there hasn't been a better time to be in privacy. Now that you've had privacy recognized for a very long time in India, it's not new, but now that you have the legislation and understanding how this law will apply to artificial intelligence systems, so decision making, that would be a fantastic challenge for all of us to get stuck in.
So, Ivana, thanks a lot. It was a beautiful guidance note, and we got a couple of questions from our YouTube live. So this program, like though we are seeing only 8 people in the chat, there are a couple of people, a couple of viewers, and in fact, many viewers who are asking questions. So now one of the questions we got from Amrut is, what will be the responsibility on Indian lawyers after this new data privacy law, as well as through GDPR or CPRA kind of international compliances? What kind of responsibility Indian lawyers will have now onwards?
Yeah. Sandesh, I'm sure you can answer that beautifully.
Yes, I can also answer that, but they want to hear from you. Yeah.
I know.
Yeah.
No, it's really interesting one because I mean, there are 2 different elements here within organizations. So lawyers will either have to work in-house or work advising clients, right? If you work with advising clients, that it becomes very important that you're able to advise them on contract, you're able to advise them on issues like, for example, according to different legislation, whether it's India, whether it's CPA, whether it's on issues such as liability and all similar issues. If you work in-house, then you'll have to work together, or either you are the privacy team, the team, or you have a privacy team, which is an intersection between privacy and technology. But but you'll have to advise your company of how to comply with the law. But the way to do this is to reach beyond legal. And the way to do this is to really have a working relationship with information security, with, if you have an AI developers team, whatever, to have a corporate approach to privacy where the lawyers can put their SMEs perspective and advise on specific matters. So, but privacy compliance is an organizational journey. It cannot be, and it's a change management strategy. It cannot
Right.
be the work on a lawyer or two lawyers. I mean, it has to be organizational transformation project.
Right. One more question we got from Vanita. She's asking, how does Western countries looking towards India whenever they are transferring their data to India? How they feel, like how safe their data will be, and how?
Well, that's not an easy question. Arguably, there are some things that we're going to, arguably, as I said, that's very much a geopolitical matter, right? And it's a very difficult question to answer because we're waiting. I mean, there's a lot of secondary legislation on the India bill, so it's a bit early. There's been a lot of discussions around, for example, access to data from law enforcement agency, which arguably is what worries the European regulators and the European a lot. But we'll have to see in the months to come. It's hard to make an assessment now.
Okay, we got many questions, so maybe we will try to email those questions because there are multiple questions.
Yeah.
So in order to stick to the timelines, it's already 5 o'clock. So I would request Merlin and Alka ma'am to conclude the session. Over to you, Merlin and Dr. Alka Patil ma'am.
Yes, thank you so much, Sandesh, and thank you so much, Ivana ma'am, such a wonderful information. It is indeed that we require the importance of data privacy. So thank you so much to madam for the department, on behalf of the Department of Law, University of Mumbai. Thank you, ma'am. Merlin?
Yes, ma'am. My name is Merlin. I'm from Human Rights Group. It is my privilege to propose a vote of thanks on this occasion. I would like to thank Ms. Ivana for sparing your valuable time and being with us. Your thought-provoking speech on data privacy, a fundamental right, something for us to think about. You mentioned that lawyers have to bridge the gap between law and the technology. Each one have to think about it and really work on it. Thank you once again, ma'am. I would like to express my deep sense of gratitude to our head of the department, Dr. Swati Rotela, ma'am, for supporting and guiding us always. I would now like to thank our dear professor, Dr. Alka Patil, for all the efforts in organizing such a wonderful session for all of us. I thank all the faculty members for all their support. A special thanks to the technical team who have helped us in organizing such a beautiful event. Finally, I would like to thank all the students and audience for your wonderful participation. I would like to thank each one of you finally, and let's now stand and conclude this session with our national anthem. Thank you.
you so much, ma'am.
Thank you.
Sandesh, now I request for all of you to complete this link. Thank you.
Thank you. Thanks a
Bye,
lot.
ma'am.
Thanks, Ivana. Thank you. Thanks. Bye-bye.